this section 3, was the most important section in the whole course, because really, if we're talking about business law, what we're talking about is establishing contracts between vendors and buyers in order to ensure a smooth flow of products and services between a supplier and a buyer. So contract law is really all about that. So what we did right off the bat was to look at what a contract law is. Really, it's a body of law that's largely developed by the courts. It consists of either oral or written agreements, and the challenge comes is when the agreements that were established are either hard to determine because they're oral, or hard to determine because they're not written well. So generally what we try to do is to encourage all contracts to be written, and they involve the simple exchange of goods or services for money or other things such as that, other consideration. The second part of this unit looked at how governments have supplemented contract law with the Sale of Goods Act. And the Sale of Goods Act, we're looking at the Newfoundland Sale of Goods Act, but the Sale of Goods Act applies right across Canada in its respective jurisdictions, okay? They're all basically the same. So the first thing we looked at is, what is the definition of contract? And really, we have to consider it as being a voluntary exchange. The reason that the word voluntary is there is because you can't be forced into it. We have such a thing as duress, which is a defense in terms of contracts. If the contract goes bad, if you were forced into it, the contract could be ruled as invalid. So what we have to have is a voluntary exchange of promises, written or spoken, between two or more parties that create some sort of obligation. And that obligation is, I'll do this for you if you do that for me. Now, you have to have not only the obligation, but you also have to have what's called consideration. And consideration means that the other person benefits too. So you have to have a mutual exchange. And this is where the word mutual comes from, is that you got to be both parties benefiting from it. And if that is the case, then it becomes legally enforceable by the court system, okay? And when we look at the court system, or when the court system looks at contracts, they're looking for all of the things that make a contract valid, such as offer and acceptance. Someone has to offer it up, someone has to accept the offer. There also has to be an intention. It's one thing to say it, is another thing to mean it. So you have to clearly express an intention to complete the contract by the parties. And that creates the obligations then that come. So without intention, there's no obligation and there's no contract. We have to have consideration, which is this issue of both parties benefiting. There has to be legal capacity. Capacity is important, and capacity is affected by things like age. If you're not of legal age, 19, then you cannot contract. There are limitations. Let me say there are limitations put on your ability to contract. If you're not of legal capacity because you're not of sound mind in some way or another, you could be insane, sick, intoxicated, some form of incapacity would mean that you cannot contract. There has to be consent by both parties, and obviously we need it to be legal. The courts will never enforce an illegal contract. There's no sense to take an illegal contract or a contract for illegal activities to the court system, because the courts will ignore it. So all of these things are essential elements, and you need to be aware of what these essential elements are. That's certainly going to be in some of those questions. So in order to create a valid enforceable contract, we have to have this offer and acceptance. That's known as consensus. There has to be consideration. This is the I'll scratch your back if you scratch mine. There has to be a promise of something, that consideration is a promise of something of value, and they must have the capacity. So we should be aware of those. In terms of the contract offer, An offer is tentatively put out there, meaning that an offer does not make a contract. I will sell you my car is not a contract. Or if I put up an advertisement that says I'm selling my car, that is not a contract. It is, however, an offer. And it must contain key terms such as what is the price or the consideration that I'm looking for if I sell my car, I want $1,000. It must contain important terms such as the subject matter and the price. Offers could be implied by conduct. That is, if I'm a sales lot for used cars, and you come in and say, I'd like to buy this car, I say, that's not offered. Yes, it is. The conduct is, this is a used car lot. The car is on used car lot. It has, all indications are that it is part of the products that are being on offer. It's probably an offer, okay? And we get into this idea of this pre-contract offers. These things are known as invitations to treat. So the car in the parking lot, on a used car lot, or a product on the shelf in Dominion or Sobeys. These are all considered as invitations to treat. It is effectively pre-offering the product to make you aware that it's there. So when a company or business encourages the purchase of a product or service through advertising, this is called an invitation to treat. A contract occurs when the product or service has actually been purchased. In terms of the contract offer, timing is often important in this because the contract will lapse, or the offer for the contract will lapse over time. So until the offer is accepted, no legal rights arise. Even in cases where the offeree may wish to accept, events such as the death or illness may occur that will prevent the formation of agreement. Obviously, too, we could have any number of things that will affect the ability of the contract to go through. The product could be destroyed. I could have the car there for sale and it catches fire and burns. There's no more car to sell. An offer may also lapse when a direct or indirect response does accept the offer unconditionally and in accordance with the terms. In other words, it gets sold. Or it could lapse if you reject the offer. So I offer my car for $1,000. You say, no way, I'm not paying that. Well, there's no offer there. Offers may also lapse with the passage of time. It's gray. What do we mean by the passage of time? A reasonable time, and we apply what's called a reasonable person's test to that to say, what is a reasonable time? 2 days, 3 days, 3 weeks, 6 weeks, 6 months? It really depends on the product. The revocation of a contract offer. I could offer my car, but I could also revoke that offer. It's when I physically tell you, no, it's not for sale anymore, I withdraw my offer. Normally, the offeror must communicate the revocation to the offeree before the offer is accepted. So you have not made an acceptance of my offer to sell the car. I tell you it's no longer for sale. There is no contract. However, if I tell you it's no longer for sale after you've accepted the contract, then we got some problems. The only requirement is that the notice of revocation must be brought to the attention of the offeree before the offer is accepted. We also have this issue of ending a contract offer. How can a contract offer be ended? So there's a number of ways that we can end the contract offer. And, the most common one is completion. I sell you my car, you give me $1,000, you drive away, there it is, done. Okay, so that's completion. Or we can mutually agree to end the contract offer. Oh, well, yesterday you were all geared to go, and today you come to me and say, well, I've had second thoughts. And I said to you, well, I've had certain thoughts too about selling it. And anyway, we just walk away from it. Specific time elapse. I give you 2 days to respond to me. You come back in 5 days. The offer's lapsed. Upon incapacity of the offer, I get run over by a bus. I'm no longer capable of selling the car. Upon revocation of the offer, I phone you up and say, sorry, before you accepted the offer, I say, sorry, I decided not to sell it. Upon rejection, you phone me and say, sorry, Paul, that's too much for that car, I'm not going to accept it. Or you phone me up and say, I'll pay you $500 for it. That's a counter offer. That is not considered acceptance. That's no different than a rejection of the offer. And I need to, if I'm the one doing the offering, okay, I will offer you the car for $500. So I have to go back and make an offer to you. The counter offer effectively wipes out the original offer. Or finally, we've got this issue of frustration. This is where the car burns in the driveway. There's nothing really to sell anymore. There is no car. Or someone comes in and smashes into it and ruins it. Again, that's what's called frustration, and it effectively voids the contract. We looked at the concept of acceptance. It's a commitment by the offeree to the terms of the offer, and it involves exactly that, a commitment. Once the acceptance is there, we have a commitment to the contract. In order for an acceptance to be law, it must be made unconditionally. So you can't put some I'll do it if. You can't do that. Acceptance must be communicated to be valid. I have to know the acceptance was there. And the question came, there are some idiosyncrasies to contract in terms of various types. We have what's called an express contract. An express contract is normally what we think of with regards to contract. It's a legal agreement in which the terms are transparent and known to all parties. So this is the typical contract, I'll call it. This is where all the terms are known. $1,000, this car right here, that's the deal. You know it, I know it. It's plain as the nose on our faces. There's nothing that we don't know. The other type of contract is an implied contract. An implied contract there's things there that we just kind of intuitively think. Things are inferred by conduct. You assume that I'm selling the car because it's on a used car lot. And this is what we mean by inferred. You go to a restaurant, the best example of inferred contract. When you sit down in a restaurant, you don't pay for it up front. In most cases, in terms of a sit-down restaurant, you order a meal, you get the bill after. So the implications are when you come in there is you're ready to contract with the restaurant to buy food. And you can't say, well, I didn't have a contract in order to get out of the meal. And most contracts are under a seal, a formal written contract that's signed, witnessed, and marked with a seal. So very formal contracts still have that seal on them. If you look at your mortgage for your house or your house purchase, it normally has an embossed tag in it, which, again, hardens up this contract in terms of from a legal point of view because there is a seal on it. Okay. Contracts must have this issue of good faith, and Canadian common law courts have only been willing to imply a duty of good faith that ensures that the parties do not act in a way that defeats the objectives of the agreement. So what we got is this implication, and that when I sell you my car and you pay me the money, that the car is a working car. Okay, I sell it to you in good faith. So there's a need for the parties to act in good faith in their contractual performance. This includes the need for a party to contract to have a regard to the legitimate contractual interests of the other party. And you're buying a car because you want to drive it, not because you want it to sit in your driveway. So you assume that the car has drivability to it. Okay, so there's a duty to act honestly. So I have to tell you, and it could affect the contract, if I don't tell you that the car has no motor in it, you buy it, you're going to say, well, you know, there's something wrong here because I bought the car from you for $1,000, assuming that it was a workable car. And I should have told you that. So again, that could create some issues with regards to the validity of the contract. We're also introduced to the term void and voidable contracts. A void contract is basically a contract that's been torn up, before it got put in place. Void contracts are not enforceable by law. Even if one party breaches the agreement, you cannot recover anything because essentially there's no valid contract in which to recover from. So some examples of void contracts include contracts involving any legal subject matter. That's what would automatically be a void contract. Contracts entered into someone who doesn't have the capacity to contract, or mentally incompetent or the like. Contracts that require performing something impossible. It depends what impossible is, but effectively, a trip to the moon, for example, for the average person, it's impossible. Contracts that are against public policy or that are too unfair, and this is where we get into this idea of, if I charge you $100,000 for the car, that's only worth $100. You look at that and say, is that really fair? Contracts that restrain certain activities. Contracts, you won't marry this guy, or that sort of thing. And these would not be upheld by the court. Voidable contracts are contracts that can be voided. So they're valid agreements, but one or both parties to the contract can void the contract at any time with no real repercussions. As a result, you may not be able to enforce a voidable contract. So contracts entered into when one party is a minor is a voidable contract. If you hire someone, for example, who's 15 years old and they don't show up to work, and you say, well, we have a contract, well, it would be almost impossible for the courts to enforce that contract because the person is not of age. Or contracts that are where one party got tricked. The old lady, I sold a vacuum cleaner to an old lady, haha, I got her money. Well, anyway, she got tricked. We're going to say that she got tricked, so that could be a voidable contract. Contract entered into one party is incapacitated. Again, they got tricked because they're incapacitated. We also talked about capacity contract, and capacity deals with the person's age primarily. That comes up. We have to be the age of majority, which in Newfoundland is 19. And the trick is, the exception is there, if the person is buying necessities. So if, for example, a minor comes in and you sell food and the minor goes and buys it and don't pay for it, you're saying, when we have a valid contract, I gave you the food, you're supposed to give me the money, we agreed to it, and the minor says, well, I'm only 15, you can't enforce it anyway. The court will look at it and say, yes, you can, because you sold it to the minor and it was a necessity. So the age and the necessity issue have to be considered together. The other issues that basically eliminate capacity contract would include insanity, drunkenness, under some form of influence, whether it's legal or not, and is there truly an intention to create a contract. So, we've got this capacity for minors, let's say 19 Newfoundland. Minors are bound by contracts for the acquisition of necessities, that's important to know, and by contracts of employment or for service that benefit the minor. Necessitaries are things required to function in our society, such as food, clothing, lodging, and transportation. There's a popular misconception that the liability will rest with the parents if the child fails to pay the debt. As a general rule, parents are not responsible for the debts of their children. Insanity, law extends its protection to those incapacitated because of insanity or mental incompetence. In a very similar way, it protects minors. Qualify for this protection, you must show that the person was not capable of making sound decisions at the time the contract was entered. The person trying to escape a contract on the basis of drunkenness must also be able to show that on reaching sobriety, the contract was repudiated. So, if you're drunk, you're temporarily incapacitated, but your obligation then is to deny the contract after the fact. Contracts in writing. Certain contracts, according to this statute of frauds, which is a government piece of legislation, certain contracts had to be in writing in order to be enforceable. Okay, so sale of land and real estate must be in writing to be enforceable. Contracts extending past 1 year must be in writing. Sale of goods specifications, sale of goods that are specified that must be in writing, Partial completion of a contract can take the place of a written agreement. So, I build half a house. We also have this issue of mistake that we have to worry about, and mistakes tend to fall into three flavors. A one-sided mistake, that is, oh, I didn't realize that. You did, I didn't. Okay? So a unilateral mistake does not normally affect the contract's validity unless the mistake was recognized and not reported by the other party. If it's a one-sided mistake, generally, you're responsible for it. Buyer beware applies unless the mistake goes to the nature of the contract. A shared mistake is when both parties make a mistake, and really, if both of us are unclear what we're getting into, there is no contract, so the contract is void. And a misunderstanding is when there's a small issue taken up, and the mutual mistakes are most common ones that hit the courts. Courts determine if it's the most reasonable interpretation in terms of the contract. Sometimes courts will look outside the contract to interpret the meaning. So where terms are clear, no outside evidence is allowed. However, if not clear, you can bring in evidence called the parole evidence rule. You can bring in evidence that supports a way of thinking, I'll call it. There is legislation affecting contract. It's called sale of goods, and it deals specifically with hard products. So products as opposed to services. In terms of enforcement of contracts, what do we do in order to enforce contracts? Well, sometimes contracts, we can argue misrepresentation there, where we got innocent misrepresentation, which is a false statement that's material, but I was unaware of it. I sold you my car. I didn't realize the motor was about to fall out of it. Okay. Fraudulent misrepresentation. I sold you my car. I did know the motor was about to fall out of it. Or negligent misrepresentation, where I acted carelessly. The car. Some contracts tend to have implied conditions or warranty items. So sales contracts can have express or implied conditions. Express conditions are ones that are written down in the contract. The contract is valid for. That's an express. An implied condition is that the car will work when I sell it to you. Express conditions are essential to the contract, clearly outlined express warranties, specific promises that the manufacturer or sellers make about the product, an implied condition or warranty promises seller to make the buyers that are not explicitly stated but presumed by law, such as the car will work. Second part of this unit looked at legislation in the marketplace. And even though there is loads of legislation, what I did was to focus on one key piece of legislation, that is the Sale of Goods Act. That's the focus of this course, is the Sale of Goods Act. And effectively, when we look at the Sale of Goods Act, it's a provincial statute. So there's multiple across Canada because it's provincial. The parties can override the provisions of the act, so they can contract above the act, put it in to say, okay, you know, if the act says that it has to be fit, you can write a contract that says it must be fit, plus it must be of the right color and these sorts of things. The act applies to the sale, the transfer of the product. In fact, the act is very focused on when the actual transfer of ownership occurs. Okay, so the Sale of Goods Act deals only with goods, tangible, movable property, doesn't apply to service contracts, and it doesn't apply to land and things like that, which is not movable property. Okay, there's specific pieces of legislation. As I say, there's many pieces of legislation. We're just looking at from movable property here. Okay. So we looked at the part one, which deals with the formation of a contract, and you can see in the legislation, you know, what it takes to form a contract. So this is the basic minimum. Contract is a contract by which the seller transfers or agrees to transfer property and goods to a buyer for money called a price. There may be contract to sale between one party owner and another. Contract sale must be absolute or conditional. Where under the contract to sale of property, goods transferred from the seller to the buyer contract is called the sale, or where the transfer of the property goods is to take place at a future time or subject to a condition of fulfillment. We'll look at that a little later on. An agreement to sell becomes a sale when time lapses or the conditions are fulfilled. This also lays out information with regards to capacity, and it talks about infants and minors, and it talks about incompetence. So all the things that we've talked about in the previous section there, this just codifies it. Form of a contract. Contract may be read in writing, either with or without a seal, or by word of mouth. Again, it codifies what we've talked about in the first section. Contract for sale of goods of value of $50 or more shall not be enforceable by action unless. So again, what this does is it has to be $50 or greater in order to make it look atable by this. The buyer accepts the actual, receives the goods sold. The buyer gives something of earnest to bind the contract. Some written notice of memorandum. Section applies to contracts referred to in subsection 1, notwithstanding the goods may be intended to be delivered at a future time. The goods may not, at the time of the contract, be actually made. The goods may, at the time of the contract, not fit or be ready for delivery. So again, what we're doing is really focusing on a $50 amount. This kind of lays out the goods that are subject to contract, and again, it just talks about the timing, if they're made or not. It could be future goods. If there's a loss of the goods, what happens? Contract is void. Again, it just codifies what we've referred to already. And again, this is the loss. It deals with the same thing. The price of the goods. The price is the contract of sale may be fixed by the contractor, or may less to be fixed in a manner agreed upon in the contract. So, for example, $10 a pound if we're selling items by weight. If there's no specific price laid out, it has to be a reasonable price. And in this section, reasonable price is a question of fact depending on circumstances. There could be third-party valuation in order to determine the price. Okay, I'm going to get my car appraised, and we'll look at it on the price will be whatever the appraisal says, that sort of thing. Time not of the essence, so it talks about the idea of timing unless a different intention appears in terms of contract. Stipulations as to time of the payment are not considered to be essential to the contract. If there's a breach of condition, what happens? And again, it codifies what we've talked about in the previous section. This is, you know, it says we could put conditions on a contract, and what happens if there is a breach. The implied conditions, again, absolutely codifying what we've talked about in the previous section. Sale by description or sample, and effectively what this says is that if we sell something based on a description, it needs to match the description. Or if we sell something based on a sample, so you have a sample of the road salt that you're ordering and you order 10 tons of it, it has to match the sample. Again, the warranty and condition exactly codifies what we talked about in the first section. And this is, again, dealing with the sale by sample, and in fact, it must correspond to the sample. This looks at the effects of the contract, where the contract deals sales for non-specific goods, property, or goods that are not transferred to buyer until the goods are ascertained. So we haven't really, you know, grown the potatoes yet that we've contracted for. Rules for this. So unless different attention appears, the following are rules for unascertained the attention of the parties as the time of the property. So where there's non-conditional contract for a sale of a specific good in the deliverable state, the property and the good passes to the buyer when the contract is made. So this rule says, okay, if the good exists already, when the contract is made, the title transfers. Where the contract sales specific good, the seller is bound to do something with the goods for the purpose of putting them in deliverable state, the property does not pass until it's done and the buyer is notified. So we got this second thing where, okay, I have to wash the car before we sell it. Okay, that's part of the deal. So to make it deliverable, I wash it, and then I alert you that the car is ready for you. Then, according to the legislation, it says that the property transfers once I alert you to the fact that that bit of work is done. Rule 3 says where the contract of sale specific goods in deliverable state, but the seller is bound to weigh, measure, test, or do something with regards to the good, the property does not pass until the act of thing is done. So I have to measure how much fuel is in the gas tank before I sell it to you, because I'm going to charge you for how much gas there is. When I do that, I will alert you, and the sale then proceeds. The fourth rule is where the goods are delivered to the buyer on approval or on sale or return or other similar terms. The property in those goods passes to the buyer when the buyer signifies his approval or acceptance to the seller, or when the buyer does not specify anything when a reasonable time passes. So effectively, Rule 4 says that where we agree to sell you a bushel of wheat, okay, and I bring it over to you, you have to take a look at it. When you signify your approval of it, then the transfer of ownership occurs. If you don't signify your approval, I leave it in your truck, but you don't bring it back to me a reasonable length of time, then we're going to assume that you bought it. Rule 5, where the contract of sale of unascertained or future goods by description or goods by description and in deliverable state are unconditionally approved to the contract, either by the seller or assent of the buyer, or the buyer with the assent of the seller, the property in the goods at the time passes to the buyer. So this is a future good, unascertained or future goods by description. I say, okay, I'm going to say some road salt. This is what it's going to look like. You say, okay, I'm going to buy that from you. You have to take a look at it to make sure it matches what I offered to you before it trades as possession. The right to dispose of an item, a little bit there with regards to it, and that is, when can I get rid of it if you don't come for it? you know, if we haven't fulfilled the contract. The risk, and effectively risk follows title. That's what this is saying. Where the goods are sold by a person who is not the owner of the goods and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title than that. So if my neighbor tried to sell you my car, you go buy it. My neighbor doesn't own my car, he can't sell it, you can't buy it. And this is what's called a saving provision if something goes wrong with the contract. So nothing in this act shall affect the enactment enabling the apparent owner of a good to dispose of them if he or she were the true owner of the goods. So effectively, if you own it, you can do whatever you want with it. The validity contract of sale under special common law or statutory power of sale in order for the goods. So if you write a contract that is above what states in this contract, there's nothing to prevent you from doing that. So here we got some good faith, again, stated in the contract. Performance of the contract, this is when you actually have to do it. So we got provisions for prepossession of goods. I wouldn't get too caught up in delivery by installments, delivery by carrier, risk of deterioration. Effectively, you know, if you own it, you take the risk. Bankruptcy too, in terms of what we mean by bankruptcy. Bankruptcy is a federal provision when you don't have enough money to pay your bills, and a trustee comes in and basically pays off or does something to pay off as many of your debts by selling off your assets. So you can voluntarily go into bankruptcy or be forced into bankruptcy by your creditors. And the trustee is then a third party comes in and is responsible for taking all your assets and basically paying off your debtors as much as possible. And different types of creditors. So, you know, other than a general understanding that bankruptcy exists and the difference between bankruptcy and insolvency, I think that would be most adequate there. Okay, so that is a very quick review of the material for the quiz. And as I say, it will work exactly the same as last time was. I wish you good luck on the quiz. Take the opportunity then to look at the various chapters, review those, review the material we've talked about, and you should be all set.